The Contempt of Court Act number 8 of 2024, to my mind, is an act of violence on the entire judiciary. I am not going to present my ideas on the entire act today, but only on its objectives. You see, the objectives to me sound quite ridiculous as well as an assault on the judiciary. Section 2, to find the objects of the act. First one, uphold the dignity and authority of a court, tribunal and institution is the first objective. This is not the business of Parliament. To uphold the authority of court is a matter for court and not for Parliament. Subsection B, protect the due administration of justice. That is not the business of Parliament. That is the business of court. The due administration of justice will be done by court, not by Parliament. Subsection C, ensure adherence to judicial directives. That is a matter for court. How can the Parliament ensure adherence to judicial directives if the judicial directives are not obeyed or not carried out? The judiciary will take action for contempt of court. It's not a matter for Parliament. E, subsection E, strike a balance between the right of expression, fair comment and compliance with judicial directives. That's a matter of fundamental rights. And also, if as I said earlier, if there is no compliance with judicial directives, the judicial officer will take action. There's nothing for the Parliament to mess around here. You know what I mean? Subsection F, set out with precision the ambit of contempt. Now, this I think is going far too far. How can the Parliament decide what contempt of court is? What contempt of court is will be decided by the judge who is presiding, against whom the alleged contempt was made. How can the Parliament say this is contempt, that is contempt, this is contempt, that is contempt? How can the Parliament say that? Whether a particular act is a contemptuous act or not is a matter for the judge who is presiding there. No limitations to what is contempt of court. And Parliament can't barge into the court's jurisdiction and say this is contempt, that is contempt, this is contempt, that is contempt. How can they say that? If the Parliament can go to define contempt, I think that is a bit too frivolous to even think about. Then we find objective at subsection G. Ensure the observation of and respect for the due process of law. How can the Parliament ensure the observance of and respect for the due process of law? That is a matter for court. That's a matter for the court. If it issues a process and it is not followed, the court will take action and punish that person for contempt of court. It's nothing to do with the Parliament. You understand what I am saying? See, I do not wish to embark on an entire analysis of the act. That will come later. Because that will take the whole day. But the act will be interpreted according to its objectives and its preamble. But I think this is, in my view, invasion of the Parliament into the judiciary, because even in it says in the Constitution that the sovereignty of the judicial sovereignty of the people shall be exercised by Parliament through courts. That's fine. It will be exercised by Parliament through courts. What is a court? Court is not a building. So, Parliament will, or at least in this way, the executive president, which itself is a dubious situation, appoints the judge. That is the court, not the building. The court is the judge. Once the judge is appointed, Parliament has nothing to do with it after that. All these provisions in the Constitution, that even that provision about sovereignty of the people, the judicial sovereignty being exercised by Parliament through courts, is subject to separation of powers. Separation of powers. Parliament or the legislature can't interfere with the judiciary. No, it can't just say, this is contempt, that is contempt. And it can't define what punishment should be given. And in any event, even this act, I couldn't see any punishment limitation being given. See? So, this is just food for thought for the legal community, including the judiciary. Just think about it. The rest of the act is far worse. I'll set that out in the next program, maybe in a few days' time. For the moment, think about it.